Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
The decision that emanated from the High Court yesterday,
right,
is one that I'd say with all certainty more or less reflects standard judgments as far as our law courts are concerned. The decision undoubtedly painful, but necessary. Why do I say undoubtedly painful, but necessary? You see, we are in a democratic dispensation. And this is a country that is governed by rules and regulations and laws. And we have come to accept as a people that sometimes even in carrying out these rules and regulations or forcing compliance as far as these laws are concerned would necessarily mean that some individuals would have their freedoms curtailed. And I know my brother Bernard agrees. It is not a palatable decision for any government to have its citizen sent to prison. That is the stark reality.
Right.
So even the National Democratic Congress government that is in force today understands this particular reality when it comes to enforcement as far as our laws are concerned. No president, no executive takes delight in sending its citizens to prison. And that is why I'm saying that it can be painful. But the necessity of law and compliance requires that for us to have a working society, many of these painful decisions ought to be taken. And so this is not a decision that the NDC is celebrating. This is not a decision that His Excellency John Dramani Mahama and the entire government are excited about. Because whichever way you turn the matter, Wontumi is a citizen of the Republic of Ghana, and His Excellency the President and the government would be pained that a citizen of Ghana would have to engage in acts that we consider unpalatable to finally end up in prison. It is not the desire of this government to have our citizens thrown in jail. Absolutely no. But you cannot also run a working democracy and protect the sanctity of our state without taking these painful decisions. And that is the reason why this is not a celebratory decision for many of us in the NDC. Having said that, let me also make the point that my brother made a point, Chairman Wontumi is a financier of the New Patriotic Party, and for that matter, the NPP was concerned about him and blah, blah, fair. But Moro, I have said on countless occasions that as political players and actors, we must begin to fish out those who jump into the fray of politics as a ruse to continue to pursue criminal conduct or activities, so that it becomes a shield when laws are used to go after them. Simply because they are political actors, our hands become tied. And when decisions emanate from our lawful authorities, we sit on platforms of this nature and seek to politicize it. When in the first place, the motivation for many of them jumping into politics is not rooted in sincerity or desire to contribute meaningfully to national development, but simply to use it as a caveat to continue to commit crimes in the name of politics. And for me, you cannot deal decisively with this Wontumi issue without ugly reality of people beginning to use politics as a way to insulate themselves from accountability. And so as a nation, and I know my brother Bernard agrees, that there's a need for us to have that discussion. And that is the reason why I was disappointed in the statement of the NPP. And Moro, have you read the statement, the issue?
I have it here.
The NPP raised three fundamental issues. And before going to the substance of what my brother said this morning.
Beyond that, the minorities also issued a statement.
Yes. That is what I'm saying. I think I'm even referring to the minority statement from Parliament.
Yes.
They raised three fundamental issues. And Bernard, this is critical. Before I even respond to the substance of your claims this morning. Three important issues. One, was the fact that Wontumi had been denied legal representation. The politics of the matter. That is clearly false. That is a lie and an insult to our laws and to the judiciary of this country, and most importantly, to the very constitution we pretend to be upholding. And I'll demonstrate why. We're all in this country. When Andy Appiah-Kubi started representing Wontumi in court, we followed the matter to a stage where we're told that judgment had been fixed for the 3rd of July 2026. After the judgment date was announced, for some strange reason, Andy Appiah-Kubi decided to refrain from acting as legal counsel for Mr. Wontumi. We are practitioners. We know how these antics are used, and I know Bernard will not disagree with me. What did the judge do? The judge decided not to give judgment on the earlier announced date of 3rd July and allowed Mr. Wontumi to replace his counsel. And that was how Atachia came into the picture. And that's why the judgment was not delivered on the 3rd of July. So it is inaccurate for you to argue, especially the MPP's minority, that there was denial of counsel in relation to the judgment. And moreover, that is not all. Even after Atachia was introduced as counsel, written submissions were made on behalf of Wontumi. It was part of those written submissions that Atachia first raised the issue of possible interpretation of Section filed a motion on notice, affidavit in support, and written submissions. The judge was not under any obligation to hear him orally on the said matter. Indeed, the Supreme Court, when they were in power, I think a practice direction was issued. And this is very important. Moreover, the practice direction was issued, practice direction, effective case completion planning strategy, 2019. Supreme Court of Ghana Law Report 442. And paragraph 15 of the practice direction, listen to this. Applications in pending cases must be dealt with swiftly to free up the court's time for trial. Accordingly, I think the two is important, oral legal submissions in the hearing of an application in a pending case shall not be entertained. Oral. Instead, the court shall, in such circumstances, grant leave to all parties to file their written legal submissions within 2 weeks from the date of the hearing of the application and adjourn the application for ruling within 1 week after the expiration of the 2-week deadline. This is a practice direction. So, Atachia subsequently writing to the judge, referencing the fact that he had a motion before him for referral, for possible referral, and the fact that he was not in the country was immaterial as far as the date of judgment was concerned. Because even if Atachia was in court, per this practice direction, the judge was under no obligation to hear him orally speak to the motion. This is a practice direction we presided over.
So you're suggesting that his absence
was immaterial.
To the delivery of the judgment.
Judgment was immaterial because he knew that the judgment date had been set,
right,
and his motions were before the judge, and the judge would dispense with those motions and proceed to deliver judgment.
right.
So even if he was in court, he wouldn't have been called upon to make submissions on this particular matter. And that point needs to be made. So it is not true that Wontumi was not legally represented. That is a lie. And the likes of Afenyo-Markin must take this country serious. Because he is a lawyer, and a senior lawyer at that. He ought to know better. You just don't throw out such lies because you want to impugn the integrity of our judiciary simply because you are not in power today. The very judiciary you used to run to on daily basis, in fact, on hourly basis when you were in power. That level of hypocrisy must be stopped. So, Moro, first, it is not true that he was denied right to legal counsel. Indeed, my brother will tell you that there were junior lawyers in his law chambers who represented him in court, and it is allowed, especially at the High Court. It is allowed. So, indeed, his lawyers were in court yesterday. Now, they also make the point that, references should be made to that of the Chachuchikata matter. And that if we said that Chachuchikata's incarceration was wrong in law, then what we have done because of the so-called denial of right, as far as the judgment is concerned, also appears to be like that of the Chachuchikata matter. That's another lie. And you see, interestingly, in the case of Chachuchikata went to court without even the faintest idea that that day was for judgment. Indeed, he had walked to court without his counsel to get an adjournment date because his counsel was out of the country. When he was forced into the witness box for judgment to be delivered.
Right.
Because the judge had said that she was tired of the adjournments. And the MPP agrees, even in their statement. You see, that level of insincerity, Moro. Listen to them. They say, this nation has been here. No, we do not resolve today whether every parallel between that case and this one is exact. That's the MPP in their statement. The facts of each differ, and it is not our role to relitigate history. This is what they have said in the statement. They agree that the facts differ, and it is not exact. But yet still, because it is their stock in trade, they wanted to confuse all of us. What did they say before even that admission? They said that what makes this history impossible to wave away is what ultimately happens to Mr. Chikata. The court held that the trial judge's own conduct of the proceedings, including delivering judgment while an appeal related to a pending Supreme Court question, remained unresolved, and doing so without proper notice to the defense had occasioned what the court itself called a miscarriage of justice. Do we have an appeal pending in this case? So how do you bring the cases together? And you seek to use the Chachuchukata matter and experience to put up a defense for Chairman Wontumi. Now, there's also an issue of referral. Mm-hmm. And they have made the point that, to the extent that there was an issue of interpretation, the judge ought to have referred the matter to the Supreme Court. And that was what they expected. And they referenced the case of ex parte senator. True. Before ex parte senator, Republic versus Mekankan, right? And Mekankan said the principle that judges should resist the temptation to refer any other matter simply because parties are alleging an issue of interpretation. The judges themselves were seized with the opportunity at the lower courts to apply the law, interpret and apply. Now, even before ex parte Seneca, the likes of the Republic versus, the Electoral Commission also, ex parte, Metro Nunu and Co., the case they presented, the Supreme Court had indicated that indeed, because of the purposive nature of interpretation, the time has come for judges to be more willing to refer such cases to the Supreme Court for interpretation. Because that is the exclusive reserve of the Supreme Court. Ex parte senator more or less reaffirmed that position in the Metro Nunu cases. But the misconception and misinterpretation of ex parte senator in this case is what is mind-boggling. It did not say that judges should refer any matter of interpretation on their decks simply because an issue of interpretation has been raised by one party to the Supreme Court. It only encouraged judges to be more willing to refer, but was also quick to add that it is within the responsibility of judges to also apply the law as they understand it. So what the judge has done in this particular instance is not in any way a contradiction as far as ex parte senator is concerned. It is clearly in sync with that principle. And that is why, if they are not comfortable with that ruling or decision in relation to the issue of referral, the avenues are not closed on them. They can still appeal. And mind you, I think in the case of Republic and Dexter, the Court of Appeal also held, the Supreme Court held that indeed, even on appeal, you can raise an issue of interpretation for the first time. So even if they did not have the opportunity to have it decided, Republic versus Dexter is a classical case that they can rely on, even on appeal, to raise an issue of interpretation. So no door is closed on them. And that is why I'm telling you that this is a meticulous judgment. Unless, of course, you want to do politics with the judgment. That is the only place that you have a problem. And so from where I sit, the judge crossed all the T's and dotted all the I's as far as this decision is concerned. And she needs to be commended. Now, Bernard, there is also an interesting perspective. When I read the NPP's, the minorities presser, about the issue of corporate view, and I think you subtly referenced
No, I said I was going to go there.
Yes, you subtly reference it. And you see, even if Afenyo-Markin was engaged in illegal mining, Afenyo-Markin has a separate legal personality. And so Wontumi should not be the one suffering from the sins of Afenyo-Markin, even though he's a director of Afenyo-Markin. Is that what they taught us in law school?
Have you read it?
No. I'm coming. Is that what they taught us in law school? Bernard. Their own celebrated Chief Justice, retired, Sofaji Akufo, in the case of Moko and Kuma.
The judge referred that.
An excellent judgment. I refer you to that case. Just go and read. The circumstances under which the corporate veil will be lifted to go after directors and owners of a company. One, when there's a breach of the company's code, it can be lifted. Two, any other legislation in Ghana, criminal in nature, you can lift it to go after the owners. And thirdly, the courts, if they believe that a company is acting as an alter ego of an individual, they can lift the corporate veil and go after the owner of the company. And that is what the judge did in this matter, which is supported by our law and cases. So if the company is of the view, if the judge is of the view that Afenyo-Markin was simply an alter ego of Chairman Wontumi, and based on the submissions before the judge, it is not difficult for you to reach that conclusion. How did Afenyo-Markin give contract to the so-called third parties to reclaim? When they admitted, when Wontumi himself admitted that he was the one who gave them the permission to reclaim. Why? Was Wontumi the general manager of Afenyo-Markin? The general manager of Afenyo-Markin himself was before the law courts and testified against Chairman Wontumi. Moreover, so if the evidence can be so compelling, then no judge would disregard the admonition as stated in Moko and Kuma. Moko versus Kuma. That it should be Moko and Kuma. Where Justice Sophia Akufo, JSC as she then was, indicated that indeed you can leave the corporate veil and go after owners of the company. That is what happened in this case, my brother, Bernard. And you know this as a lawyer. This is basic. Why the politics? You see, if we feel that this is not appropriate, this is unlawful, like I always say, the appeal processes are open. He has 90 days to file his appeal. Nobody, and this one is as of right. I hope I'm right.
Exactly.
It's as of right. What's the name?
As of right.
As of right.
No leave.
No leave is required. So he can actually appeal. Let us go through the appeal process. But more, I have read the judgment. Not all, I must admit. But I can tell you that that judgment would be very difficult to overturn, even on appeal.
Oh, really?
Very, extremely, next to impossible. Unless, of course, you want to play politics with the judgment. Regardless of the emotional attachments and sympathies we have for Chairman Wontumi, because he's a colleague, as far as the political space is concerned. But the law, they say, is the law. If you read that judgment, it is going to be extremely difficult. Even you, listening to my brother today, about the claim that, oh, he gave them permission to go and reclaim. And so if they were doing illegal mining, it had nothing to do with him.
Should
He did not know. No, please, let's be patient. I was patient. He did not know that they were doing illegal mining. Really? And you believe that story?
The court couldn't prove that.
Please, please, please. You see, that's the point. The court is not the responsibility of the court to prove allegations. It is the responsibility of the prosecution to prove allegations. The court only takes a decision based on evidence before it. And to the extent that the prosecution was able to demonstrate that indeed these people were engaged in illegal mining with the express authority of Chairman Wontumi, to the extent that his defense could not counter that. It's not anybody's fault. It's not the court's fault.
He raises the issue about their claim as against Chairman Wontumi's claim, and why the courts decided to take their claim as basis.
But when we appear before
drawing
courts,
the conclusion that he was involved.
Moro, when we appear before courts, Party A has his claims.
Yes.
Party B will also have his claims. It is the decision rests with the judge after listening to both sides. So he cannot sit in this chair and ask the question why, because he's not seized with that authority. He was not the judge in the matter. The judge listened to them. The fact that I have made claims in court does not mean that the judge will agree with me. Sometimes I'll make claims and back it with evidence, and the judge will be minded to listen to me. Okay. That's what happened. We all go to court with claims.
No problem. I'll allow you to continue. I need to get back. You've been talking for almost 30 minutes.
No, it's not true. It's not true. I'm not even speaking for
that like 24 minutes?
No, that's not true. That's not true.
Am I going to get the same
You
time?
started at 8:30. Because he was being uncomfortable. You see how he was rolling in his chair when I was speaking. That's why he thinks that I've spoken for long.
I was going to address...
I don't always like this. When I'm flowing, then you come in with...
Let me address this very important issue.
No, let me finish. 8:45. No, we started at 8:30.
You know what I mean? Your submission.
So no, mine was not 8:45. It was after 8:50. Trust me.
8:50.
Yeah, 8:55.
You know what? It's 9:29.
I started at 8:50.
No, it's been 26 minutes.
No, stop.
26 minutes.
No. But he spoke
and
more.
I never interrupted. You were asking me like...
asking me questions.
All right. So you land so that you land in 2 minutes so I can go. Because I need to take a break.
Yeah.
I can go for a break and then come back to you.
Don't do this.
Because I need to take a break. But you land in 2 minutes.
Moro, for me,
yes,
where I sit, I think that it will do Wontumi and his defense team a hell lot of good if the NPP decides to move away from the politics. Ordinarily, I had no plans of running commentary on this matter.
Right.
Because I don't want to see it as a political football. But to the extent that a statement was issued by the MPP, minority, and the MPP's office, we are duty-bound as communicators of the ruling NDC to also help explain the matters to the citizens of the Republic of Ghana, because we know the stock in trade of the NPP.
Right.
The judges may not be able to come out and explain why certain decisions are taken. Not every Ghanaian would have the benefit of reading the judgment.
Right.
But, you see, Bernard, you are a practitioner. When you rose on your feet, the judge did not say no to you, even though you were not part of the legal team of Chairman Wontumi. She listened to you as a friend of the court. In line with procedure, you mitigated.
Okay.
Even though my strategy for mitigation would have been different, listening to you and your interviews. Even though my strategy for mitigation would have been different, and I can assure you that with proper mitigation, Wontumi probably would have gotten the 15 years. But it was because even your mitigation was lax and porous. Because if you appear in court and you are telling the judge that because the man has so many companies, a man who is being accused.
Come on.
Oh, well,
It's public Okay, you finish. I'll get my bites right.
If you appear in court and you are saying that because the man has so many companies and he's employed people, because of that, there's a need for the judge to mitigate. When he's used the same company or some of the companies, for which reason he's before the court.
Okay.
And you are trying to tell the judge that because he has employed people, the judge should temper justice with mercy.
All right.
When there were many other avenues you could have reached out to.
All right.
For example, maybe, I don't know whether he's even a first-time offender or not.
All those things were adduced.
Yeah, first time offender.
All those things were
You
adduced.
raised that. Okay.
In fact,
Let's take a short commercial break. There are people who have made this show possible. Let's acknowledge them.
I'm not PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.